Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. It is great to be with you here today, as it is every single Sunday from 8 to 9 a.m. right here on this station. Join me every week for All Things Marcellus, the informational show for you, the landowner. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania. And at the Clark Law Firm, my focus is, as always, on you, the landowner. Not oil and gas companies, not pipeline companies, not energy companies. I represent landowners, oil and gas right owners. Never have, never will, never would consider representing any oil and gas or pipeline companies. Represent clients, landowners for gas leases, gas lease amendment and modifications. Been talking a lot about that recently. Pipeline agreements, going to touch on some of that today. Also, well site agreements, damage releases, royalty issues, unitization issues, you name it, any issue related to natural gas development here in Pennsylvania, doing more and more estate planning. You'll hear me talk about that as well. Again, anything related to natural gas, that's what we do on behalf of the landowner. So if you ever need representation, you can always contact my office directly at 570-307-0702, regardless of where you are in Pennsylvania or beyond, if the property or gas rights are located in Pennsylvania. Again, 570-307-0702. And of course, if you haven't, or if you have, go back again, pagasleaseattorney.com, pipelineattorney.com. Whether you're looking for information or representation, take advantage of pagasleaseattorney.com. Take advantage of pipelineattorney.com. Both websites are loaded with information for you, the landowner, and include access to All Things Marcellus, the radio show. I've been doing it since 2010 weekly, so you can go back and listen to many hours of shows. And I'll tell you, take advantage of the new feature we've added recently that you can search the website for a topic of your interest. So you can go click on the search button. If you want to learn about pipelines, it'll direct you to pipeline information. If you want to learn about selling oil and gas rights, it'll direct you there. So whatever it is, whatever it may be, leases, extensions, check out the blogs as well. Another thing that we're doing is we're going to start, well, we do it sometimes, we're going to start doing a little more regularly, sending out these newsletters, which will include blogs or writing of articles that I do. So if you're interested in that, contact the office, either 570-307-0702, or you can email me through pagasleaseattorney.com, through pipelineattorney.com. Just say, hey, like to sign up for the newsletter. We'll put you on the list. We'll hit you with the newsletter when it comes out. We don't bother people. We're not going to solicit you. We'll get you that information. And then if you need us, you need anything, hey, we're here. If not, we want to get you that information. Okay, enough of the introductions here. Let's jump into it. I'm excited about today's show. Really like the topic. I always like talking about pipelines, but what I'm going to do, we're going to blend a couple things here together. And as I say, I'm always looking for topics that are going to apply across the state, and also looking for topics and subjects that maybe we can use, and though we might talk about pipelines today, the same type of considerations, analysis, evaluation still applies, whether you're looking at a pipeline agreement, whether you're looking at a gas lease agreement, a meter site, compressor site, whatever it may be. So we're looking to find overlapping issues to make sure that we make the most of this hour of All Things Marcellus. So, okay. In recent times, I've been talking a lot about oil and gas lease extensions and top leases, which are leases where you would enter into when you already have an existing lease. So that would be a top lease. So if you have a lease that expires next year, company comes out and says, hey, we want to lease you, maybe because that company is the same company that holds your lease and they know that they're not going to be able to get to your lease, so they want to give you a new lease. They may give you a new lease called a top lease, or they may seek to extend or modify to extend your existing lease. So those are possibilities. Or we see this happen too, that maybe you're leased to a company today and the other company comes and offers you a new lease. You say, well, wait a second. I still have a lease with company A, the company I'm leased with now, that doesn't expire until next year. Well, company B says, yeah, we know that, but we're pretty confident company A is not going to do what they need to do to hold or maintain your lease, so we're going to offer you a top lease. Very important. We're seeing a lot of that. Why? Because the low natural gas prices are having an impact on what companies are willing to do as far as operations on the ground, namely drilling. Companies have halted completely or drastically scaled back the drilling that they're doing and plan to do in Pennsylvania in the short term and over the next year or two. So what does that mean? Well, when a company is not drilling, they're going to, in this environment today in Pennsylvania, they're going to need to extend leases to enter into new leases because they're not going to drill. So they're not going to do what they need to do to continue active leases now. Leases, so if you have a 5-year lease, and the company doesn't drill or do anything within 5 years, they're going to end up losing that lease. And so what do they need to do? They would need to come out and they need to extend your lease. They need to modify it. They need to do a top lease or a new lease. They need to do something. If they're not going to drill, they're going to lose that lease. Now, again, this is a generalization. There's a lot of specifics involved. But the point is, and what I've been talking about recently, is these modifications, amendments, extensions, and top leases, and how in today's marketplace this can be a great opportunity. I'm not going to go back into this, so don't tune us out here now. We're not going to go back into that. I've talked about that a lot in the last several shows, and I tell you, I so encourage you, if your lease is expired or expiring, if you have an extension offer to extend your existing lease or a top lease offer, I promise, do yourself a favor, go back to pagasleaseattorney.com, read about these subjects, go back to pagasleaseattorney.com, listen to the radio shows on the subject. You need to be thinking about this, and it is a number one area today where landowners are making bad decisions, in my opinion, being taken advantage of, and it's because of a lack of information. We want you to be informed. So you don't have to call. You don't have to call. Love for you to call. Don't have to. Go to pagasleaseattorney.com. Go to pipelineattorney.com. But listen to the shows. Check out these subjects. Unbelievably important. You should not simply extend or modify your lease. You shouldn't just enter into a top lease. There's many potential opportunities, and we need to take advantage of them. So I'm not going to go, again, too far back into this, but I just want to remind everybody. And it's very relevant to what I'm going to talk about here today. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and we're going to talk about now is a combination subject that includes pipeline agreements and pipeline agreement terms. So we're going to dive into that, and I'm going to tell a nice little, hopefully neat, entertaining story. Well, I don't know how entertaining, but somewhat hopefully. So, all right, I'm talking about in general here these extensions. Well, just like you don't want to simply extend your oil and gas lease without understanding everything, getting good advice, knowing what your options are, understanding what your leverage is, understanding if you do or you don't do it, what's going to happen in the future, the best that we can predict. The same analysis and considerations and evaluations apply when considering extending or modifying an existing pipeline right-of-way agreement. If you as a landowner entered into a pipeline agreement in the past and you did not have an attorney who knew what they were doing or didn't have an attorney at all, I can pretty much assure you that you did not enter into the best pipeline agreement that you could have. Just simply, I see hundreds and hundreds of these, and no matter what, no matter you did some research online, these older pipeline agreements tend to be very poor or company-friendly agreements. So if you didn't have a lawyer or if you had a lawyer, but if you didn't have a lawyer, when you negotiated the pipeline agreement or you signed a pipeline agreement in the past, and the company now comes to you and they want to modify or simply have the route changed and you initial off on maybe changing a route or initial off on a change, stop, put your pen down, call me or call somebody, but you may have an opportunity. These older pipeline agreements, and I'm going to talk about one here today, and this one here was entered into in 2008. It is a terrible landowner agreement. So, and these guys, they didn't realize. They thought they had a good deal. There are many of these. I don't care if it's 2008, 2012, 2013, or any time in between, before or after. We need to make sure that if you're going to be extending something, that you're not extending a bad agreement. And 99% of the time, if you didn't have an attorney, if you entered into this, the farther back, even worse, but you probably can do better, and you may be better off simply declining or negotiating a new agreement. We can't lose these opportunities. I can't repeat it enough, so I'm going to repeat it again real quickly. If you're asked to extend a gas lease, pipeline agreement, or any contract whatsoever, you need to call me or somebody. And I'm sorry, if you don't call me, call somebody. But you need to do that because people are extending terrible agreements. People are locking in 12.5% royalties for longer periods of time. People are locking in leases that allow for deductions when they may not have to. We gotta change this. We gotta turn this tide. We gotta say, hey, wait a second. Extension, modification, those words in your head, you should see the word potential opportunity words, but you should see opportunity, potential opportunity, that you need to say, wait a second, I need to evaluate this. Low gas prices can and does present opportunities to many landowners. We need to make sure if you have an opportunity, you are seizing it, not watching it sail by. And what's great is that usually in order to miss the opportunity, you have to sign something. So when you're being asked to sign something, word opportunity should come to your head and say, well, wait a second, before I sign this, I need to do some investigating to see if this creates an opportunity for me where I can turn back and change my original lease agreement, which is not as good as it could be. Or, as we're going to talk about today, change my pipeline agreement. Or in the case I'm going to talk about today, eliminating a terrible pipeline right-of-way agreement. And not because I'm a genius, but because I do have the experience and understand what we're doing. This landowner calls, says, hey, I'm asked to extend this lease. We stop it all, and we're going to get rid of this old pipeline right-of-way agreement that could be an albatross on this property for literally decades and well over a century into the future. I'm going to tell that story. I think it's really interesting. And again, this applies to everything, leases, anything with an extension. This applies to. So stay tuned. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here with you every Sunday from 8 to 9 a.m., and I'm going to be right back after this short break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I got to remind you, I'm here with you every single Sunday on this station from 8 to 9 a.m. to bring you, the landowner, the information that you need regarding natural gas development here in Pennsylvania. All right, let's jump into it here. So, okay, now remember, stick with me. We're talking about opportunities for landowners. I've been talking about this, but there's a twist this week. We're going to talk about pipeline agreements. So, landowner, here's the story, here's the situation. I'm going to try to tell a story, and then we'll try to have some education here throughout the story. So, landowner actually calls because they have a request to modify or extend their gas lease. So what do? Say, hey, okay, listen, maybe let's do a first step. We'll do a review and consultation. Send me, and they live far away, they sent me their gas lease and any other documents that they had signed. In this case, there was a pipeline right-of-way agreement, and they sent me their extension offer, and we set up a call. So I go back, I look at all these documents, we set up a call. And again, this call can be from people with all across the country. This case, it was out in the more western, north central part of the state. So they send me the information, whether by mail, fax, email. They send it to me. We set up a call, and we talk about what is being offered, and we talk about what the options are. We assess the leverage. We go through all of the different things. What are the pros, the cons of doing this? What are your options? Go over everything in detail. But in this case, I said there was an old pipeline right-of-way agreement. Now, this pipeline right-of-way agreement that they signed, and this is what I'm going to do. I'm going to take some time to go through it. But the pipeline right-of-way agreement that they signed, in this case, it was in 2008, but it doesn't have to be that. It could be 2012, 10, any number. Just so happened that this one was signed in 2008. So I look at this pipeline agreement and I'm scratching my head saying, oh man, this is a really bad pipeline agreement. Really bad. Boy, it stinks that they signed this agreement. Well, one of the things that I make a note and say, well, I want to make sure that I ask them, has a pipeline or pipelines been installed under the terms of this old pipeline agreement? When I say old, I mean existing. I've dealt with pipeline agreements from the 1800s. So this was only 2008, so not that old, relatively speaking. But in any event, so I look at this, I said, well, I want to ask these guys, has the company used this pipeline agreement? So during our call, it turns out that they didn't use the pipeline agreement. So these landowners, they have an extension of the oil and gas lease, but they have also an old pipeline easement agreement that we believe that the company who's offering them the lease extension has the rights to the older or the existing 2008 pipeline right-of-way agreement. Let me clarify that some, make this a little bit simpler. So landowner has an offer to extend their gas lease from a gas company. In this case, the lease that they want to extend, the gas company inherited or was assigned the gas lease from another company. I'm not going to use real names, so we'll call them we'll do company A, company B. So okay, company A enters into a gas lease with this landowner back in 2008. They also enter into a pipeline right-of-way agreement with the landowner. This was actually very common in the north central Tioga County, that type of area in Pennsylvania, where landowners simultaneously entered into a gas lease while at the same time entering into a pipeline right-of-way agreement. Many times, the landowner didn't even realize that they were entering into a pipeline right-of-way agreement. It's also funny, I see sometimes where the lease that they entered into has a lot of pipeline restrictions. It says, hey, you can't put pipelines across my property unless they're carrying my gas, or other restrictions. And then what happens is they don't even realize that they're simultaneously entering into a pipeline right-of-way agreement that allows a company to put pipelines anywhere they want on the property. So we got to make sure when we're signing things, we understand what we're signing. It doesn't make sense that a landowner would sign a gas lease with all of these pipeline restrictions and then simultaneously sign a pipeline right-of-way agreement with essentially no restrictions on pipelines and giving extensive rights to the company to run pipelines across the property. Doesn't make sense. Clearly, in speaking with the landowner, it was never understood that that's what they were doing. So, okay, resetting. I'm going to speak with the landowner about the request by the gas company to extend and modify their existing gas lease, which is about to expire. So, look at the lease. Send me their lease. Send me their pipeline agreement. Send me everything that they've signed. If I need more, I let them know. But look at this stuff. It took less than a half an hour, I think, in this case, to even look at everything. So we look at everything, review everything. I know what to look for, see what the problems are. So, okay, aside from just looking at the decision of, hey, landowner, do you want to enter into an extension or modification, and why, and look at all the different reasons why they may want to wait or why they may want to do it now, those are always going to be major factors that we're considering. But in this case, I also look and see this old pipeline right-of-way agreement. So I say, hey, landowner, in my notes, these are things that we need to talk about. So I say, landowner, what's going on with this old pipeline right-of-way agreement? Or I shouldn't say so old so much, but existing pipeline right-of-way agreement, because I see it's a really bad agreement. Landowner says, well, they've never put any pipelines. Nothing's ever happened there. So I say, okay, what's the big O word from earlier? Opportunity. First thing we're looking at, in everything I'm looking at, is there an opportunity here? It's like, imagine visually looking at someone digging through the haystack, looking for that needle of opportunity. And sometimes they're big jumbo needles. I don't even know what you'd call them. Big giant pole vault sticks that stick right out there that say, wow, this is a big opportunity. Sometimes you got to really dig in to find that opportunity that's hidden. But many times there's opportunity, and it's very difficult to find opportunities if you don't know what they are, what to look for. And in most cases, the landman isn't going to tell you about all these hidden opportunities for you as the landowner, because what do? They represent the oil and gas company or the pipeline company. That's what they do. Their job isn't to go out there and advocate for you. Their job isn't to say, hey, you know what? Yeah, we're offering you this extension, but you may be able to get rid of this old pipeline right-of-way agreement if you do the extension. You're not going to generally find that, and certainly that's not what happened in this case. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here with you every Sunday from 8 to 9 a.m. on these stations to bring you, the landowner, the information that you need regarding natural gas development. All right, so resetting briefly. Set up now, going to talk to the landowner. Well, my job is find opportunities, identify opportunities wherever they may exist. In this case, I say to the client, I talk to the landowner, hey, there's this old pipeline right-of-way agreement, aside from all the other issues we're talking about. Has the company ever used this pipeline right-of-way agreement? And I was very happy to hear the response, no, they've never used this. Said, okay. As we look at this offer to extend or modify your lease, let's talk about, and I'm going to use examples here. Let's say that the original lease was 12.5% royalty, which we know is the lowest royalty allowed by state law. So right away, that's going to put up a lot of red flags or super bright yellow flags of caution. We need to really think about, is this the right thing to do at this time? So we're going to look at it we're going to give it a lot of scrutiny, and we're going to look at, is this right for me at this time? And there's a lot of different things we're going to look at there, but we're not going to focus on that now. So one thing is we're going to look at the royalty rate. The other thing is, okay, well, what are they offering you on a per acre bonus? And can we increase that offer? Sometimes we can, sometimes we can't. But we're going to study and we're going to look for every opportunity we can to improve the terms of the existing lease that the company wants to extend or modify. So we're not just looking, but boy, are we looking at the royalty percentage, at the royalty calculation language. Does it allow for deductions of post-production costs, pipeline costs? Is the company allowed to take deductions for items like pipeline gathering and transportation and compression fees under the terms of the existing lease? If deductions are allowed, that may be something that we can improve. So, and that's a major item. So we're looking at, what's the royalty percentage? Are deductions allowed under this lease? Then we're looking, is there PU clause language? Is there shut-in language? Is there other beneficial language to you, the landowner, in your existing lease? And can we improve on the language that is there? So we're looking at all of those things. But in this case, what was really interesting is there was, uniquely interesting, but not that uncommon. There was an old pipeline right-of-way agreement that was signed with this gas lease. Doesn't have to be signed simultaneously, but in this case it was. So we said, well, geez, if you, landowner, are going to extend this existing oil and gas lease, let's see where we can improve. So again, we're looking at those financial parts. We're looking at what about the operations on the property. In this particular case, to do the extension, one of the things we were looking at is, okay, the existing lease allows for a lot of surface activity. The company can operate on the surface, put roadways on the surface, well sites, meter sites, and of course, pipelines because of the pipeline right-of-way agreement. So we're looking at that. Where can we improve? If you're going to extend or modify your lease, where can we improve it? Sometimes it's financially, royalty percentage, no deductions, bonus, a per acre bonus. Sometimes it's going to be with the detailed terms of the agreement by adding additional addendum terms, by restricting surface operations on the property, maybe completely, maybe in part, meaning partially restricting operations. We need to look at that too. And of course, for some landowners, restricting surface activity is very important, and for some landowners, it's not so important. But the point is, we know so much more today than when you entered into an existing lease. So we need to, go into that haystack and start looking for those opportunities. And in this case, immediately we saw several and were able to significantly alter and improve the terms of the existing lease versus, and I'm going to talk about, we got rid of the pipeline right-of-way agreement. Jumping to the end there, but I'm going to explain how. We're going to talk about this process here in a second. But looking for that opportunity, identifying the opportunity, and if you didn't do that and simply signed the old lease and the modification, you'd have it the same lease terms, the same bonus, the same royalty percentage, the same royalty calculation and deduction language. All of that would be the same, and you'd have this 2008 terrible pipeline agreement still in place. But we were able to make significant changes because we identified the opportunity and we seized upon those opportunities to enter into a much better lease and, as you'll hear, get rid of, terminate the pipeline right-of-way agreement. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. As you know, I'm here with you every Sunday from 8 to 9 a.m. on these stations, and I'm going to be back after this break, and we're going to talk more about, I'm going to go through the story and explain what we did, and I'm also going to discuss why was this pipeline right-of-way agreement so bad? What's he talking about? I'm going to explain why it was a bad agreement and how it was a very nice benefit to get rid of it. I'll be right back after this break. Okay, we're going to jump right into it here. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So what we're talking about is this. Landowner says, hey, I have an oil and gas lease extension or modification. They contact the office. They set up a review and consultation. They send me, whether by mail, fax, or email, their existing lease, the new lease offer, and any other documents like a pipeline right-of-way agreement or something else that they have signed previously, and I review everything in preparation for this call. These landowners are located very far away. We do it by conference call, and we sit down. I have the papers all in front of me. They do, and we go through, and I explain ideas. And what I'm doing when I'm looking at this is looking to identify potential opportunities. In this case, and we're going to talk hypothetically here. In this case, this hypothetical case, landowner has an offer at, say, their existing lease is 12.5% royalty. Well, also, they had signed a pipeline right-of-way agreement when they signed their existing lease. Now, here we go. We look at this and say, well, geez, I look at this and say, well, boy, this pipeline agreement is a really bad agreement for the landowner. I'm very familiar with what pipeline companies are doing out in this particular area. And again, it's not good to have that particular pipeline agreement out there in any area, but especially this area where this landowner is located. So one of the questions that I have that I want to talk to the landowner about during the call is, hey, what's the status with this old or this existing, I keep saying old, this existing pipeline right-of-way agreement? And I was very happy for the landowner to give me the answer I was hoping that I was going to hear. And that answer was, well, there's been no pipelines installed under this agreement. And in fact, they weren't even really understanding exactly what the agreement meant. But this was really good news. That made me really happy. I liked the sound of that because I said, hey, when we're identifying opportunities, one opportunity and one negotiation chip here to put on the table is, or a potential demand, depending upon how firm you want to be. But one is, hey, maybe we can get rid of and terminate this old pipeline agreement that can come back to haunt you at any time in the future, a year, 2, 3, 4, 5, or maybe even 50 years or 100 years in the future, that it could affect your children, your grandchildren, or whoever owns the property. So it doesn't necessarily have to be 100 years. It could be next year or the year after. Let's get rid of this agreement for so many different reasons. This pipeline agreement, I'm going to go through some of these terms, is a terrible agreement for the landowner. Not only is it bad for the landowner, but I'll just say generally this agreement doesn't define the number of pipelines, where the pipelines could be located. So now you have a property where you have a pipeline right-of-way agreement that you've given a company the authority and power to install pipelines, as many as they want, anywhere on your property. That's not what you want to have. That's just not what you want to have. And from the beginning, you should never sign an agreement that says something or gives those type of rights. You should not do that. And a newsflash, you don't have to. I've never had a client sign an agreement like this. I've done agreements with over 50 different companies all across Pennsylvania. Have never had a landowner sign an agreement where we didn't identify where this pipeline was going to be located. Attach exhibits, require installation according to where it's staked or flagged on the property. We can't give wide open blanket authority in these pipeline right-of-way agreements. And the good news is, if you know to ask, you don't have to. You don't have to. And even better news, well, we know that now every listener knows you need to ask. So start asking. Whether I'm involved or somebody else or you, start asking. I'm not going to agree to that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9 a.m. to bring you the information that you need regarding natural gas development. So, okay, now, landowner says, okay, yeah, they've never installed a pipeline under this pipeline agreement. And I say, all right, we know we want to look at financial terms of this agreement. We know we want to improve on weaknesses. If you don't have a shut-in clause, if you don't have a pew clause, if you don't have good royalty calculation language, we know we want to look at that. But we also know we want to look at what else can we do. Those are the big javelin needles in the haystack. Those are the big pole vaulting sticks. I don't know what they're called, but the how about that they're called the pole vaulting poles? That makes a little bit of sense, since you're pole vaulting, that you would be doing that with a pole. And I apologize, but hey, look, we got to have some fun here and fun with ourselves. So what I was saying was, if you're joining me, say this guy's nuts. What I'm talking about is we're looking for opportunities, and I made the analogy earlier that opportunities can be like hidden needles in a haystack, or they can be these big giant needles, which I liken to like a javelin or a pole vaulting pool. a stick or a pole that you use to pole vault. Those are real easy to see, but we're looking for hidden things as well. So the big giant poles or needles in the haystack, they're going to be the financial terms. They're going to be the royalty terms, but we're also looking for the needles, the smaller opportunities, which actually shouldn't say that. Large opportunities, but harder to find. Large opportunities, but harder to find. So what do we do here? In this case, say, hey, landowner, well, this old pipeline agreement is terrible. And let me explain some of the reasons why it's terrible. I gave you some overview here, but I'm holding it here in front of me. And I'm not going to go through it all. I'm going to do some shows coming up here because I tell you, honestly, pipeline right-of-way agreements is some of my favorite shows because I do so many and have done so many pipeline agreements. And I can tell you this, and I say this often, they're like leases in the olden days where you're presented with something, but you have the ability to heavily negotiate what you're being presented. And generally speaking, not specific advice for anybody, but generally speaking, you can really negotiate most of these pipeline agreements, substantially negotiate them to your benefit. And it's a shame. It's an absolute shame, but landowners are not taking advantage of that. It kills me because there are hundreds and hundreds of people who are continuing to sign bad pipeline right-of-way agreements for tens of thousands and in many cases hundreds of thousands of dollars less than what they could get if they negotiated and understood their leverage and effectively negotiated. And it's happening all the time. I can't say it enough. I'm sorry it's so repetitive, but you should, pipeline agreement, sorry, call me or call somebody. Don't just sign these pipeline right-of-way agreements. I deal with the guys and the ladies who have signed or the people who own the property before them signed bad agreements, and we see them come back and haunt people who signed bad agreements or the people who owned the property before them signed bad pipeline agreements. So in this case, I'm not going to go through all the terms, but I will do shows in the future about pipeline terms and really explain bad agreements. But I'm going to highlight some of these things in this document. So this was the pipeline right-of-way agreement that these landowners signed when they entered into their lease. Didn't have to be that way, but it could be something that you just signed. It didn't have to be simultaneous with the lease, but in this case, they signed it simultaneously with the lease. This pipeline right-of-way agreement is really bad for the landowner. It allows for the installation of an unlimited, without limit, number of pipelines that the company wants to put in. They can put in as many pipelines as they want, which we don't want to do that. We don't want to do that. There's no extra compensation for additional lines. There's no limitation. When in the future can they do it? We need to limit the number of pipelines. And where do we want to start? One pipeline only. If we're going to do two pipelines, we want to have them installed simultaneously. And we want to get more money. If we can't get them installed simultaneously, then we want to have certainly more money, and we want to have time frames. When can you put in a new pipeline? Sign an agreement today, you put a pipeline in next year, or 3 years from now, 2 years, whatever the time may be. Well, do they come back in 15 years, 10 years, 5 years, 100 years? We want restrictions and limitations. Perhaps more disturbing here, no limitations on location. Not even that the company would consult with you in the future, which I don't like at all. That's still not what we want, and we don't do those agreements in my office, but that would be better. Still terrible, but better than no location language in this at all. Company could just someone say, hey, we're going to put it here, and there's nothing you can do about it. Nothing you can do about it. Don't ever sign an agreement like that. Never had a client sign or represented anyone that signed that type of an agreement. So many, those alone are just terrible. No indemnification. If there's a problem, you can get sued. No liability protection. Hopefully you'd never be found at fault, but if you were at all, you could be held responsible. They're not going to defend you. You're going to have to pay for your own attorney's costs. So let's pray to heavens that nobody gets hurt in this process, that nothing occurs that you're ever subject to a lawsuit, because you're going to have to defend yourself. And that's going to be very, very expensive. There are so many other things, and I guess I don't want to go too far on this, but this thing, ingress and egress, they can construct roads. They can go travel all across anywhere in your property without restriction to go to and from the pipeline. They can put above ground facilities, valves, drips, meters, other necessary facilities on your property, on the property. Doesn't account for additional compensation. And the topper, well, maybe these guys made a lot of money, right? Maybe it was really good. No, they're going to get $5 per foot of the right-of-way. So not per foot for each pipeline installed, $5 per foot of the right-of-way, whatever it is that the company uses, because they can't tell you now because you have no idea where this right-of-way may be located. All right. That is absolutely terrible. Terrible, terrible, terrible. Very terrible. So what do? We say, hey, they haven't used this. This may be an opportunity to erase this right-of-way agreement. That's such a bad agreement. And I'll tell you, here's something to think about. This right-of-way agreement devalues this property for as long as this right-of-way agreement exists. If you were going to go out and you were going to buy, let's say this is a 20-acre property and it has a house on it. You're going to go out there and you're thinking about buying it. And you find out that there's a right-of-way agreement that exists. It hasn't been used. That right-of-way agreement, you look at it and you say, holy heck, the company can come. If I buy this property in this house, they can knock on my door in a week from now and say, hey, we're going to put a pipeline through my front yard. And there's nothing I can do about it. And then they say, not only are we going to do that, but we're going to put a metering facility on your property and some above-ground valves. And you're saying, I don't think I want to buy this property. Landowner who has this agreement on their property, your property is going to be much more difficult to market or sell because you have this agreement. And who in their right mind is going to want to buy a property when a company can come anytime, whether it be 1 year or 50 years from now, and say, oh, by the way, we decided to put a pipeline here and we're going to put things above ground and we're going to add some additional pipelines in a few years and we're going to be digging up your property for many years into the future. Who wants to buy that property? Well, I can tell you I wouldn't, or at least I wouldn't want to pay a lot of money for it. So it's really important. Can we get rid of this? And I'll jump to the end and say, yeah, we can, and we did. And we'll tie up how and what happened here after this next break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And remember, you can join me right here on this station every Sunday from 8 to 9 a.m. So I'm going to jump into it here. We're talking about this pipeline right-of-way agreement, looking for opportunities when the company asks you to sign a gas lease extension, modification, top lease, pipeline agreements even, or extensions or modifications. Look, anytime you're asked to sign anything, it may be an opportunity, and we got to identify it, and then we need to seize it. So in the kind of little case summary that I'm doing here, landowner calls, they have an extension offer to sign the gas lease, to modify it, to extend it. In this process of doing a review and consultation, it usually takes an hour or two. We look at this. They send me their information. I look at it. I prepare for the call. We have the call. We cover a wide variety of subjects. But in this case, one of the potential opportunities was there was a really bad existing pipeline right-of-way agreement. And when I spoke with the landowner, I found out that the company hasn't used this agreement, hasn't installed any pipelines. So a potential opportunity exists to get rid of this pipeline right-of-way agreement. To summarize this process and not get too into the weeds here, well, what we did was we negotiated. We looked to negotiate royalty percentage, royalty calculation terms, per acre payment, the bonus payment, the timing of the bonus payment, when is that going to be made, Also looking to add some shut-in language, some other language that didn't already exist. We're looking to add PU clause language. We're looking to negotiate the language and the financial terms to make them stronger and as strong as we possibly can, while simultaneously evaluating, is this a good time to enter into an extension? What are the potential negatives? What are the potential positives of entering into an agreement now or waiting to see when the market recovers, if it does, which I'm pretty confident it will, but waiting, that's a potential possibility. So we got to talk about that. Well, in this case, one of the things we're also talking about what is important to you in your specific case. And in this case, the landowner was very concerned about trying to limit future surface activity, well pads, pipelines, operations on their property. They've seen what these activities have done. They've seen 20-acre pads cleared out. They say, hey, look, we really want to restrict this. So we then look, okay, what are your specific concerns? Can we address them? If we can, how do we address them? In this case, no matter what, I deal with pipeline agreements all the time. I said, boy, we got to try to get rid of this. And this landowner didn't even realize that was a possibility and didn't really understand exactly what they had signed originally. So we talk about it. And as part of this process, the company who has approached them for a top lease agreed to release or give up this existing pipeline right-of-way agreement. That was a big win. When you're looking at and evaluating, do I or do I not want to sign this extension, and we're using these scales of decision-making, well, this idea of getting rid of this old pipeline agreement, that weighs heavily in this case for the landowner to extend the agreement. Now, that's not the end of it. We also negotiated, in this case, to limit all other surface activity on the property. So at least it would allow the company to operate anywhere without restriction, but then also a separate pipeline right-of-way agreement that would have allowed as many pipelines as the company wanted and had no location restriction as to where the pipelines could be located, that also allowed for surface facilities for pipelines, valves, pig launchers, receivers, metering sites. All of those things we were able to negotiate to get rid of the pipeline right-of-way agreement while simultaneously negotiating compensation items. So in this case, when we ultimately, and the landowner ultimately weighed everything out, said, hey, to eliminate surface activity, to get rid of this old pipeline agreement, to get out from underneath these old documents, and considering the compensation offered, the royalty percentage that's offered, this made sense. This was a good time to enter into this agreement. So that's what the landowner is doing. Of course, that may not be the right decision for every landowner. You need to make the right decision for you and your situation. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here with you on this station every Sunday from 8 to 9 a.m. So now I'm going to get into this little twisty nuance that occurred here. So, company who offers lease extension agrees to give up the rights to the pipeline right-of-way agreement. Great. That's a major factor in this landowner's decision to go ahead and extend their gas lease, but to have an agreement to release or give up the pipeline right-of-way agreement. We agreed upon the money. We agreed upon the royalty and the royalty calculation language. We added some additional addendum terms. We have a deal that the landowner is pleased with, and it makes sense to move forward and enter into it. Well, when the document, this is where it gets tricky, and this is where it's extremely tricky for a landowner or an inexperienced attorney. In this case, company then says, okay, here's the document that we submit that we will sign to release or give up these pipeline rights from the existing pipeline agreement. Here's what we present to you. Looks good, says, hey, we give up our rights in this pipeline right-of-way agreement. Well, it doesn't have that agreement, say, attached to it as an exhibit, so there's no confusion. And what's very interesting in this particular case, the original pipeline right-of-way agreement was never actually recorded at the courthouse. So there's no official record out there of this agreement. However, we have a copy. We know it exists. We have a copy of the agreement. But for some reason, the company never recorded the agreement or a memorandum in the courthouse to show that this agreement existed. They don't have to do that. It's good practice to do it, but they didn't do it. So one of the questions then that I had is, hey, gas company, we know that you were assigned this gas lease from another gas company, and we assume that you were also assigned the pipeline right-of-way agreement that was entered into the same day that the landowner entered into the gas lease, but we don't know that with certainty. Also, this pipeline right-of-way agreement isn't recorded, so we don't want to be sandbagged, and we need to know that you, company, who say, yeah, we'll give up our pipeline rights, we'll give up this pipeline agreement if you sign this extension, well, we need to know for sure that you have those rights, that you own that pipeline right-of-way agreement, so you can indeed give it up. And we don't know that for certain with the information that we have today. So yeah, we're really happy that you're going to give up this pipeline right-of-way agreement, but you know what? We need to make sure that you actually own it. It's real easy to give up something you don't own. So it turns out when we request and require additional language to make sure that we're not negotiating to give up a pipeline right-of-way agreement that the company doesn't even have the rights to, we say we need to have this additional language. We need these protections. Sure, no problem. Well, as it goes through, the company who was ready to sign right away, well, now it shows, when we request and you know what to ask for, they say, we're not completely sure what's going on with this pipeline. Well, yeah, we would have signed what we presented to you, but then when you want to tighten it up, they say, well, you know what we're going to have to do? We're going to have to go back and get that first company to sign off too, because we don't know for sure that we have these rights. Very interesting. This is the type of thing. Now, the other company's going to do it. We're going to get this whole thing done. But this is a classic example. You have to know. So it's very detailed. There's many nuanced, detailed, technical issues and items you need to be looking at. And as an individual landowner, that's extremely hard. As an inexperienced attorney, that's extremely hard. But we listen to all things Marcellus, and we know better. And we're going to make sure that when we enter into an agreement, we understand the agreement, we understand the pros and the cons, we've evaluated future expectations, and we're going to enter into the best possible agreement for you, the landowner. So I'm going to close out here with kind of a quick little commercial, so forgive me, but this, I'm working on the Atlantic Sunrise project with many of my clients, or with several clients. Just want to say, look, if you have one of these type of pipeline right-of-way agreements, you should at least get a review and consultation. But any pipeline right-of-way agreement, it's one of the big areas where landowners are signing bad agreements. Get information, even if it's just an hour or two review and consultation. Get the information. It's been extremely helpful for people all across the state, in northeastern Pennsylvania. I've represented, I say this because it gives you an idea of the experience. Hundreds of landowners with pipeline right-of-way agreements with over 50 different companies in the state. I know we can help you. Sorry about commercializing this, but I'm telling you, we got to stop signing bad agreements. We got to maximize these agreements. Learn more. Give us a call, 570-307-0702. Check out pagasleaseattorney.com. Check out pipelineattorney.com. Check out the testimonials. We can help you. Let's stop signing bad agreements. Again, you've been listening to All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. Have a great week, everyone.